in the United States, if you hold someone under the law enforcement model, caught in the United States, you have to read them their rights, you have to present them to a court. If they're in military custody, you don't have to do that. But what system fits the situation best should be left up to the executive branch. We're just creating an avenue for military custody that can be waived.
That is correct. We're providing flexibility, which we should provide in order for the executive branch to have what they want, which is the flexibility. And there are many, I think many of our colleagues, who believe there's too much flexibility. But whether that is right...
Oh, yeah, they're over here. There are plenty of our folks believe.
Whether that's right or wrong, that's right or wrong, the facts are that in this bill, there is flexibility. It's carefully laid out. The President will lay out the procedures and notify the Congress of those procedures. But the point is that we do provide the very flexibility that the President of the United States has sought. We give them that flexibility. And it seems to me for the characterization of this bill to be that there is no flexibility, that somebody must go into military detention, is inaccurate. We ought to debate policy, but we should not debate what the words of a bill are. One other thing, is it not correct that when it is said, as the senator from California did, that this provision has an unprecedented and new authority for indefinite detention of American citizens without trial, that as a matter of fact, that we had in Section 1031 in the bill filed months ago language which would have exempted American citizens, and it was the administration that wrote 1031 the way it is now and has approved of that language. Is that not correct?
That is absolute. And let's talk about indefinite detention and what it means. When someone's captured as a member of al-Qaeda, the Bush administration has had people at Guantanamo Bay for years. Are being held under the law of war. Do you agree with that, Senator Levin?
I'm sorry, was this
the Bush administration has prisoners held at Guantanamo Bay for years now who have not been prosecuted. They're being held under the law of war.
That's correct.
The Obama administration has continued to hold at least 48 under that same theory. So
believes it has that authority.
Right. I believe they're right. So all the Congress is saying to the President, this one and future presidents, that we agree with you that if the person is a member of al-Qaeda or an affiliated group, you can hold them as an enemy combatant without the requirement to let them go at an arbitrary point in time. But under the law, if they're at Guantanamo Bay or captured in the United States, they have a habeas right to appeal that determination to a judge. But under our bill, do you agree with me, Senator Levin, that we've done more than that? We've created an annual review process so the person being indefinitely held will have some due process every year.
The Senator is correct. The Senator has led the way to have this kind of additional protection for those prisoners. There is greater protection in this bill because of that review process than there is without this bill.
Right, and we should do that.
And there's one other, if I could, Senator McCain, one other question, because the Senator is an expert in this subject. Is it also not true that for the first time, in terms of determining whether or not a person is, in fact, somebody who needs to be detained under the law of war, for the first time, when that determination is made, that person is entitled to a lawyer and entitled to a military judge.
Let me tell you how you're dead right. I offered an amendment to the first bill we put on the table here on the floor about this, and I had a requirement of a military lawyer being given to the respondent at a combat status review tribunal. Every person being held as an enemy combatant by our military gets a combat status review tribunal. We're saying that tribunal has to be chaired by a military judge, and we're saying they can access a lawyer. That, to me, is a welcome change. The Obama administration and the Bush administration decided to put the military judge requirement in place, but this now is a statutory requirement. So the next president is going to be bound to do that. So we're trying to create a process to allow a status tribunal hearing to be done more like in a more due process friendly fashion. We require a judge and we provide access to counsel. To me, that is a giant step forward.
And it is in law for the first time. Is that not correct? If we get
for the first time, it is now not
would be
the
in law.
whim of the administration. It will be the law of the land.
If this bill is enacted.
If this bill is enacted.
So I would, to kind of summarize this issue for our colleagues, we believe that an al-Qaeda operative is an enemy combatant, and therefore the assumption should be that that enemy combatant should be under military custody, whether it be in the United States or any place else
That's
in
correct.
the world. I would argue especially in the United States, since that poses the greatest threat. And, however, with our assumption that that person should be held under military custody, we still give a very wide waiver in case there are extenuating circumstances.
Not
in other
only
words, we're saying that we assume that an al-Qaeda operative or a suspected al-Qaeda operative is an enemy combatant wherever they are on earth, and therefore they should be under military custody unless there is some reason that the President determines otherwise. Now, the counter-argument that we're hearing, really in summary, is that because that al-Qaeda operative is apprehended in the United States, that therefore that they should fall under civil authority, thereby negating the assumption that it's an enemy combatant. It is a common criminal. So, you know, this is a very important principle in this discussion that we're having. How do you treat a suspected al-Qaeda terrorist that wants to, in the case of the underwear bomber, blow up a plane with 100 and some odd passengers on it? And shouldn't that person therefore be treated as an enemy combatant and therefore subject to all of the rules of military people who are under the supervision of the military? So isn't that kind of really what we are debating here? And the ACLU and the left, in all due respect, feel that that person should be, first of all, that al-Qaeda operative should be treated under our criminal system rather than treated as an enemy combatant who wants to do great harm to the United States of America. Is that an accurate description of what we're talking about here?
Yes, sir, with one caveat. There's a line of thinking that we should be using federal courts exclusively, that military commissions are not appropriate in any circumstance, and that we should be using the law enforcement model once we deal with an al-Qaeda operative, particularly here in the United States. What we're saying in this legislation is that the battlefield includes our own homeland. But there's also, and so that argument being made by the ACLU, I think we'll beat that because most Americans feel like we're not dealing with somebody that robbed a liquor store. These people present a military threat, and we should be able to gather intelligence in a lawful way. But the administration's concern was, are we overstepping executive power? Now, I have, quite frankly, said I'm concerned about that. Peter was concerned about that. Dave was concerned about that. I've been really concerned about that because I don't believe you can have 535 attorney generals or commander-in-chiefs. So what we did to accommodate that concern is what you said, Senator McCain. We started out with a military custody requirement that can be waived, and the procedures to be waived are in the hands of the executive branch. And as Senator Levin has indicated, this to me is very flexible and is so flexible that I feel very good about it. If it were a mandate to put everybody in military custody and try them in military commissions, even though I think that's the best thing to do, I would object. Because the flexibility to make those decisions needs to be had in the executive branch. There may be a time when an Article III court is better than a military commission court for an al-Qaeda operative. I don't want the Congress to say Article III courts could never be used. I don't want the Congress to say military commissions are bad. We've now got a good military commission system. We've got a process where the homeland is part of the battlefield. The individual being captured on our homeland can be held to gather intelligence under military law. And if somebody smarter than us believes that's not the right model, they can change the model. And that's the best we can do. And that's the best I'm going to do, because I'm very worried that in the future we're going to lock ourselves down into policies that would have an absurd outcome, that if you made it to America, we can't gather intelligence, which would be crazy. No good reason for that.
But the Senator yields.
Yes.
In addition to saying in this bill, in addition to providing in this bill that the determination as to whether or not somebody is al-Qaeda is to be made through procedures which the President will adopt,
Totally.
number one, which is flexibility.
Right.
Number two, that determination shall not interfere with any interrogation which is undertaken by civilian or any other authorities. Is that not correct? We protect interrogation. And finally,
totally
on top of that, there's a waiver that is provided. So we've got all of that protection. So the statements that are made on this floor and in some of the press that somehow or other we are pushing everybody who is determined to be al-Qaeda into the military detention system is not accurate, because we have those three protections. The procedures for that decision as to whether someone is al-Qaeda are procedures which the President is going to adopt. Secondly, we only apply this to al-Qaeda, not to everybody who might be
captured. It's not somebody walking down the street.
We have a waiver for triple protection to protect what you rightly are sensitive to, and that is that there be flexibility in the executive branch. All of us may say we want it done one way or another. We may presume that it be done one way or another. We may wish that it be done one way, civilian or military. Some of us have different opinions on that, but that's not the point. That's not the issue. The issue is, what does this bill provide? And this bill provides a reasonable amount of flexibility and does not tell the President you must turn somebody who is suspected of being al-Qaeda over to the civilians at any point or to the military at any point.
And if I may just add another layer of process here, some people on our side say that's way too much. You should just throw these people in military. Senator Lieberman, my dear friend, if you left it up to Joe, everybody caught as an al-Qaeda operative would be thrown in military custody. They would be held as long as we need to hold them, and they'd be tried by military commissions. At the end of the day, that's sort of where I come out, but I am not going to create a 535 commander-in-chief body here, because there are times when that may not work. So what we've done is what you've said. So if you capture someone at home, it's just like you've described. And the reason, to my colleagues on this side, I wanted to build in the things you just described is because I'm very worried about crossing over out of our lane into the executive lane. And I think we've created a great process. But here's what happens to that al-Qaeda operative. Not only does the executive branch have the flexibility to go one way versus the other, starting with the idea of military custody, but all the things you said are true. But what do they have beyond that? If someone is being held as an enemy combatant, there are regulations requiring that they be presented to a combat status review tribunal, now with a military judge, access to counsel. I think it's within 60, I can't remember the time period. That is done. Then they have the right to take that decision and appeal it to a habeas federal district court judge. So no one in America is going to be held as an enemy combatant that doesn't get their day in federal court. But their day in federal court is a habeas proceeding, not a criminal trial. And if the judge agrees with the United States that you are in fact an enemy combatant, then you can be held indefinitely, but we require an annual review. If the judge says let you go, they got to let you go. This is the best we can do. This is a hybrid system. No other war do you have access to a federal court. But as I said before, this is a war without end. And if we don't watch it, an enemy combatant determination can be a de facto life sentence, because there'll never be an end to these hostilities, probably in my lifetime. So I recognize that, and working with you and Peter and others, we've come up with a process now that allows a federal court to review the military decision. We'll have an annual review process if the judge agrees with the military. And that, to me, is due process that makes sense in a war without an end. Something you wouldn't do in World War II, but something we need to do here. So to the critics, please read the damn bill. And I apologize for saying it that way, but you're talking about things that don't exist. There's plenty of flexibility and waiver requirements in this bill. No one's being held indefinitely without due process. Not only is this due process you wouldn't get in any other war, this is due process beyond what exists today, only if we can pass this bill. And I don't mind being considered by some of my colleagues as maybe too friendly to due process. The reason I am so passionate about this, what we do sets a precedent for the world and the future. If one of our guys are captured, I can look the other people in the eye, Al-Qaeda could care less, but other people might, and say that we're a rule of law nation. I believe in the rule of law, but there's a difference between the rule of law of fighting a crime and fighting a war. And I'm proud of the military legal system. I do believe the military justice system has a role to play in this war. Military commissions, the judges are the same judges who administer justice to our own troops, the same prosecutors, the same defense attorneys, the same jurors. So I'm proud of the military legal system. I'm proud of the federal court system. I want to use both. But, Senator Levin, we have been working on this for years. This is the best work product I have seen, and I hope my colleagues will understand that we thought long and hard about this, and if we don't get a process in place that has some definition, some certainty, some guidance, that we're letting our nation down. This is a good bill. I hope people will vote for it.
If this bill contained the provisions as described by our friend from California, I would vote against our bill.
So would I, at my own detriment. I don't want to mandate the executive branch to do everything like Lindsey Graham would like. I want to start with a theory that makes sense and provide flexibility to change it if that makes sense. I don't want anybody to be in jail because somebody in the military said you're an enemy combatant. I want a federal judge involved in a sensible way. I want due process to make sure we can tell the world you're not sitting in a jail because somebody said you were guilty of something. You had a chance to challenge that. But to the critics, I will not stand for the idea that we can't defend ourselves under the law of war, because I believe we're at war. And in war, you have the right to hold enemy prisoners. You don't have to let them go to kill you again. And in war, you can hold people and gather intelligence in a humane way. That's what we're able to do under this bill. Fight a war within our values. I will yield.
Senator from Kentucky. Senator from Arizona.
I see that senator from Illinois on the floor, who I know is very heavily involved in this issue. We've been now debating this amendment for, I think, about 3 hours at least, and a number of speakers from both sides. I would hope that perhaps we could go ahead and vote on this amendment. I was informed, and the chairman was informed by Senator Reid, that there is a limited amount of time that can be spent on this bill. And I realize how important it is to him, but we have no further speakers right now. I know you want to speak on it, but would it be agreeable that after we have exhausted the number of speakers that we could go ahead and vote on the amendment? Well, you know, it's really too bad, because you know what the...
Senator from Arizona.
Let me just say, the senator from Illinois, this is an important issue, and I understand how important it is to him. But this legislation, sir, has a lot to do with defending this country. And for you to hold up the entire bill because you don't think it's been discussed enough, I think is a disservice to the men and women who are in the military, that this bill addresses their concerns, their needs, and the needs of the nation's security. So we took up this amendment in the belief that we were going to go ahead and debate it and vote on it. And so the senator from Illinois, if we are forced to not be able to complete work on this legislation, I think he bears a pretty heavy burden on this, because we have a lot of other provisions in this bill that are also vitally important to the security of this nation. We've had spirited debate. I've been involved in this legislation of the National Defense Authorization Bill for a quarter of a century, and we've moved forward, and we've had debate, and we've had votes, and I would hope that we could do that so that we can move forward to other issues. The senator from Kentucky is on the floor with an amendment that he would like to have debated and voted, and we have like 100 more. So I hope that the senator from Illinois, after we've had sufficient debate, that we could go ahead and vote on the amendment.
Senator from Michigan, or from Illinois.
Mr. President, I don't know if I now have the floor.
Yes.
I will proceed. First, let me thank my friend from Arizona. We have served together in the House and the Senate, been friends for many years. I respect him very much. And certainly have the highest respect as well for the senator from Michigan. But I will tell you this, if the argument is, if we don't vote on this amendment tonight, the security of the United States is in peril, is a little hard to make. Because we're not going to finish this bill tonight, number one. And number two, it's pretty clear the administration opposes this particular amendment. At least I've been told they do. And number three, if we're talking about something as fundamental as changing some laws in this country relative to the United States Constitution, I have to agree with Senator Leahy, chairman of the Judiciary Committee, and Senator Feinstein, chairman of the Intelligence Committee. This great body should take the time, debate the issue, and vote on it in a timely fashion. I'm not here to filibuster this matter, but I am here to discuss it. And I would like to say to those who've come to the floor and say it's imperative that we move now to change the way we deal with terrorist detainees in the United States. I'd like to make a record for them. For the record, for the last 10 years, we have dealt with alleged terrorists in the United States, and during that 10-year period of time, 300 alleged terrorists have been successfully prosecuted in the criminal courts of America and incarcerated safely in American prisons, 300. And during that same 10-year period of time, 6, count them, 6 have been subjected to prosecution through military tribunals. So the score is 300 to 6 for those who want to change the system, 300 saying we have a pretty darn good Federal Bureau of Investigation, we have excellent lawyers in the Department of Justice, and the American court system has responded well to keep us safe. So the notion that this has to be changed tonight to keep America safe, I don't know there's any evidence to support that. And I listened to some of the arguments on the floor here, and I want to call to the attention of my colleagues, this is not an insignificant change in the law. If Section 1031 is enacted into law, for the first time, we will be saying in the law that you can detain indefinitely an alleged terrorist who is an American citizen within the United States of America.
Would the senator yield?
I will yield after I complete my point.
Okay.
I believe that most of us feel that if someone is charged with terrorism, an American citizen, that normally they would be subjected to constitutional protections and rights as American citizens. And for those who believe in military tribunals, and I know the senator from South Carolina does because he has been engaged in them personally and feels that they are an honorable and effective way of prosecuting individuals, he knows as I do that we have gone through in the last 10 years a series of Supreme Court cases that have questioned whether or not we are handling military tribunals in the right fashion. The law is not settled when it comes to military tribunals, but the law is clearly settled when it comes to Article III criminal courts, to the point that 300 terrorists, alleged terrorists, have been successfully prosecuted and convicted. So I think this is worthy of debate. It is a valid issue. The security of America will always be a valid issue on the floor of the Senate. But let us do it in a thoughtful way. This matter was not referred to the Senate Judiciary Committee. It was not referred to the Senate Intelligence Committee. It was decided by the Armed Services Committee. And as good as they are, as great as the people are who serve on that committee, there are others who should have a voice in the process. I yield to the senator from South Carolina if he has a question which he'd like to direct through the chair.
Thank you. I'd just
South
like to
Carolina.
respond. Number one, it is good to debate. It is good to have discussions about important matters, and Senator from Illinois is right. There's nothing more important than defending the homeland. Now, let me just tell you, as the law as I understand it, the Hamdi case was an American citizen captured in...
Mr. President,
Majority Leader.
would my dear friend from South Carolina allow a unanimous consent request?
Absolutely.
And I would ask
Majority
that my friend's statement not appear interrupted in the record.
Without objection.
Mr. President, I ask unanimous consent the Senate to proceed to the consideration of the conference report to accompany H.R. 2112, an act making consolidated appropriations for the Departments of Agriculture, Commerce, Justice, Transportation, and Housing, and related programs. There will be up to 90 minutes of debate, equally divided between two leaders or designees, that upon the use or reading back at the time the Senate proceed to vote on the adoption of the conference report with the 60-vote affirmative vote threshold. Before there's a response to my request, I would tell everyone we're going to be in session tomorrow. I've spoken to the two managers of the bill. We will likely not have votes tomorrow. In fact, I don't think we will have votes tomorrow. But I would say to everyone, if you have amendments to offer, you should offer them, because the time for the defense authorization bill is winding down. People can't sit around and say, we'll do something next week, because next week may be a lot shorter than people think.
Will the leader yield for a question?
I'd like to change that to 90 minutes to 120 minutes.
Without objection.
Mr. President.
Is there objection?
Mr. President, I would object, reserving the right to object.
Senator from Kentucky.
Would the senator yield for a question? I think I may be able to satisfy Senator Paul.
I hope.
Senator from Michigan.
Would the leader make that unanimous consent effective after there's 5 more minutes of discussion, or
We
between
can make it
ourselves?
effective
And
after half hour more discussion.
and after, excuse me, Senator Paul calls up an amendment, and after Senator Merkley just calls up an amendment and then lays them aside.
Yes.
Is there objection as modified?
Well, would that be acceptable?
I would accept the modification with pleasure.
Without objection.
Finally,
So moved.
we get somebody to start offering some amendments.
And if I could just comment very quickly to my friend from Illinois. I just want to... So
Did we get the consent?
I think he ordered that.
Oh, all set? Okay.
I just...
South Carolina has the floor.
Okay.
Anybody needs to make this
I just wanted to ask the
go
senator
further,
a question.
faster.
Is the senator aware?
But
Senator from-
I would only
Senator-
say, I would say to my
Senator
friend,
Majority Leader.
I yielded, I mean, my friend from South Carolina yielded to me for a unanimous.
Senator from South Carolina has the floor.
If I may,
Right, he was-
if I may, respond to my friend from Illinois. Hamdi was an American citizen captured in Afghanistan. He had joined al-Qaeda, the Taliban, I guess, in that case. We captured him when we went into Afghanistan. We brought him back here and we held him as a enemy combatant for intelligence gathering purposes. His case went to the Supreme Court. The Supreme Court said you could hold an American citizen as an unlawful enemy combatant. You just got to create procedures, a due process requirement. Eventually, the court said that every unlawful enemy combatant has a habeas right. The law of the land is clear that an American citizen helping the enemy overseas can be held indefinitely, but they have the right to petition a judge as to whether or not the initial determination was correct. If the habeas judge believes there's not enough evidence to hold you as an enemy combatant, then they have to release you. But if the judge agrees with the government that there is enough evidence to hold you as an enemy combatant, you can be held indefinitely. This president is holding 48 people at Guantanamo Bay who have never seen a criminal courtroom because of the theory of law of war.
Senator from Illinois.
South Carolina, I yielded for a question.
Okay.
That's correct.
All right. Okay. The question
You bring it
is,
to a
do you
question
agree with
mark?
what I said?
Let me just say to my colleague, and I respect
Illinois.
you and count you as a friend, the difference, the critical difference here to the Senator from Michigan, Senator from South Carolina is this. The Hamdi case involved an American citizen, part of the Taliban, arrested in Afghanistan. Okay? You made that point when you said the word overseas. Unfortunately, Section 1031 does not create that distinction. An American citizen arrested in the United States, charged with terrorism without any connection to overseas conduct, or having been arrested overseas, I should say, is still going to be subject to indefinite detention. The only thing I would add is this. I think this is a good exchange, and I think we need more. And the notion that we have to hurry up and get this done in the next 5 minutes is not, I don't think, an appropriate way to deal with this. I know Senator Paul and Senator Merkley are waiting, and I would be prepared to yield the floor at this point. If this matter comes up again this evening, I hope that we can engage in further discussion.
I just have a question, if the senator would yield, of the senator from Illinois. Is the senator aware of the fact that Section 1031 in the bill that we adopted months ago in the committee had exactly the language that you think should be in this Section 31, which would make an exception for U.S. citizens and lawful residents? That was in our bill. And I'm wondering if the senator is aware that the administration asked us to strike that language from Section 1031 so that the bill in front of us now does not have the very exception that the senator from Illinois would like to see.
I have the greatest respect for you and the administration, but I think I'm also entitled to my own conclusion.
No, I understand, but I'm just asking the senator, is the senator aware that it was the administration that asked us to strike that language, the exception for U.S. citizens?
And not being a member of your committee, I didn't follow it as closely as you did. I respect you very much and take your word.
Thank you.
I yield the floor.
Senator from Kentucky.
I ask unanimous consent to set aside the pending amendment and call up my amendment number 1064.
Is there objection? Without objection, the clerk will report.
The Senator from Kentucky, Mr. Paul, for himself and Mrs. Gillibrand, proposes amendment number 1064.
I ask that the reading of the amendment be waived.
Without objection.
Mr. President, this amendment will call for a formal end to the war in Iraq. Our founding fathers intended that the power to commit a nation to war be lodged in Congress, and that's what the Constitution says. The power to declare war is one of the most important powers given to Congress, and it should remain in Congress. John Madison wrote at the beginning in the Federalist Papers that the Constitution supposes what history demonstrates, that the executive is the branch most prone to war. Therefore, the Constitution has, with studied care, vested the power to declare war in the legislature. We are calling for a formal end to the war in Iraq as the troops come home, as the President has planned, by January 1st. This will reclaim the power to declare war that is vested in Congress. It allows for checks and balances and is an important milestone and an important retaining of power for Congress. So I will ask very careful deliberation of a formal end to the war in Iraq by supporting this amendment. And at this time, I'd like to yield the floor to Senator Merkley.
Mr. President. Mr. President.
Senator from Arizona.
Just briefly, I'd ask the indulgence of the senator from Oregon. I just would ask the senator from South Carolina if he would finish the response, and I'm sure it would only take him 2 or 3 minutes. Finish the response.
I promise you I will.
So I ask unanimous consent that Senator Merkel be recognized after, a couple of minutes after Senator from South Carolina. Thank you.
Without objection.
Thank you.
Senator from Oregon.
The exchange with Senator Durbin was very good. The law of the land is pretty clear, unequivocal in my view, that an American citizen captured overseas can be held as an enemy combatant, and every enemy combatant held at Guantanamo Bay or captured in the United States has habeas rights. The Padilla case involves an individual who was captured in the United States, suspected to be an al-Qaeda operative, and was held for 4 years appealed his case to the Fourth Circuit. The Fourth Circuit said you have a right to a lawyer to prepare your habeas case, but you don't have a right to a lawyer to interrupt the interrogation. You can be held as an enemy combatant, and they can gather intelligence for an indefinite period. That's the law of the land, and that's why the administration came over and said, you know, the provision that me and Carl were talking about really would change the law, and they're preserving the ability, if they want to, they don't have to do this, basically to hold an American. And here's the thought process for the body and the nation. If you capture somebody not just involved in terrorism, that's not what we're talking about, al-Qaeda operatives involved in an attack on the United States, if they're an American citizen, who cares? If they're doing that, we want to know what they know, interrogate them and hold them for prosecution, or just hold them so they won't go back to the fight. And that is the law. All we're doing is creating a procedure for that system to be followed. We're not doing anything different than already exists. And this notion somehow that the homeland is not part of the battlefield is absurd. Why in the world would you give somebody rights who came to America to attack us different than you would if you caught them overseas, when the point is they're involved with the enemy, American citizen or not? We're just creating a procedure that will allow that situation to be handled. So that's why the administration objected to our language, and I think they're right.
Mr. President.
Senator from Oregon.
Mr. President, I ask unanimous consent to set aside the pending amendment and call up my amendment number 1174.
Without objection, the clerk will report.
The Senator from Oregon, Mr. Merkley, proposed amendment number 1174.
Mr. President, I ask further reading of the amendment be waived.
Without objection.
Mr. President, I introduced this amendment with several original co-sponsors, Senator Mike Lee, Senator Rand Paul, Senator Tom Udall, and Senator Sherrod Brown, and I would like to thank them for joining in this effort to address our military presence in Afghanistan and the fact that our military forces have done such an excellent job of completing the original missions of destroying al-Qaeda training camps and bringing to justice those responsible for 9/11. But over this past decade, our mission has changed to one of nation building, a mission that is obstructed by vast corruption, by extraordinary traditional cultural resistance to a strong central government, and by a very high illiteracy rate. These factors should have us rethinking how to have the most effective use of our military forces, our intelligence assets, in taking on the war on terror, and that we should be engaging in counter-terrorist efforts using our resources wherever the terrorist threat emerges across the world, rather than concentrating these vast resources in Afghanistan. Our sons and daughters and fathers, mothers, sisters and brothers could not have done a better job in their military mission. But it is right now that we do less nation building abroad and we do more nation building at home. It is right that now we refocus our effort to have the most effective strategy to take on terrorism around the world. And it is in that philosophy that we come together in a bipartisan fashion to propose this amendment, and we ask that colleagues take a chance to consider it and join us in redirecting our efforts to be more effective. Thank you, Mr. President.
Mr. President.
The Senator from Michigan.
Mr. President, first I ask unanimous consent to add Senators Akaka, Chambliss, Blumenthal, Inhofe, Gillibrand, Ben Nelson, Stabenow, and Udall, Senator Mark Udall, as co-sponsors of amendment number 1032, which is the pending Levin-McCain amendment on counterfeit parts.
Without objection.
Secondly, Mr. President, we are going to move now, I believe, to the conference report.
But I do want to remind folks of what our colleagues, what Senator McCain said, which is we will be here tomorrow morning, and we're here to try to clear amendments. We want to be able to give our colleagues as much opportunity as possible to debate and to clear amendments. But we've got to move this bill. We're not going to be given a whole week after we come back to get this bill adopted, hopefully.
Mr. President.
Senator from Arizona.
What's the pending business before the Senate?
S. 1867 is still pending.
The amendment, isn't the Paul amendment pending business?
The Merkley amendment is pending.
The Merkley amendment is pending. Mr. President, I ask unanimous consent that the Paul amendment be the...
No. It's regular order. It's our amendment.
Okay, that the regular order be...
The Levin amendment is now pending.
Levin McCain amendment is pending.
Levin McCain amendment is now pending.
I thank the President. I would just like to say, just to say a couple of words about the Paul amendment. I would just like to point out we will still have 16,500 Americans still in Iraq for an extended period of time. Now, whether they should be there or not is the subject of another debate on another day, but to then not be able to do whatever is necessary to protect the lives and safety of those men and women who will continue to serve the country, sometimes in various difficult circumstances, I think that this amendment is unwarranted. I finally would like to ask my colleagues who have further views on the detainee issue if they would come over and add their voices to the debate and the discussion, because we really would like to dispose of this amendment. I respect the Senator from Illinois' desire that everybody be allowed to speak. We have been now speaking on this single amendment for, I believe, well over 3 hours. And so if there's further discussion on the Udall amendment, I would very much like to have a vote on it so we can bring other important issues before the body. President, I yield the floor.
Senator from South Carolina.
I ask unanimous consent to enter into a colloquy with my colleague from New Hampshire.
Without objection.
Okay. We're talking about this amendment. Let's debate this amendment. Let's vote on this amendment. But really the heart of the issue is whether or not the United States is part of the battlefield in the war on terror. The statement of authority that I authored in 1031 with cooperation from the administration clearly says that someone captured in the United States is considered part of the enemy force regardless of the fact they made it on our home soil, and the law of war applies inside the United States, not just overseas. The authorization to use military force right after the war began allowed us to go into Afghanistan and use detention and capture and military force to deal with the enemy in Afghanistan and other places overseas. What has the enemy been, to my colleague from New Hampshire, do you believe al-Qaeda considers American soil part of the battlefield?
In response to the senator from South Carolina, I would say that unfortunately our country is the goal for al-Qaeda, and we saw that with September 11th and the horrible attacks on our country that day that killed Americans. They want to come here and harm us and hit us where it hurts us the most. And so unfortunately America is part of the battlefield, and to put ourselves in a position where we would not allow our military, intelligence, law enforcement to have the tools they need to gather the most intelligence to protect Americans on our soil would lead to an absurd result.
And does the senator agree that with Senator Levin and a very bipartisan work product, we've now created a legal system that says the following: if a U.S. citizen, a non-U.S. citizen, is involved in an al-Qaeda attack on our nation and is captured here within the United States, we're allowing our military the ability to hold them as part of the enemy force, to question and interrogate them for intelligence gathering, and that right we have overseas to hold somebody now exists in the United States because the threat is the same.
I would say to my colleague from South Carolina, when you spoke on the floor, you really captured the most important part of this, which is without the amendment that we have here that we've been debating, we do not even give our military, law enforcement, intelligence officials the ability to decide which system is best in each instance. And because, rightly so, when you're in our country, when you're an American citizen, you are given your Miranda rights, you're told you have the right to remain silent, you have the right to have a lawyer. And we need to make sure that we don't create a distinction where if you're captured abroad, you're treated one way, and we're giving our officials maximum flexibility to gather as much information as possible to protect our country. But if you make it here, the rules are different, and we don't give the officials that are set to protect us every day, both on the military and the law enforcement end, the flexibility that they need to gather maximum intelligence. And it would just be an absurd result to treat it differently. It would almost encourage, come to America, unfortunately, to attack us, because you'll actually be given greater rights if the attack occurs here.
Would the Senator agree that what we've been able to do on the committee is basically say in law for the first time that the homeland is part of the battlefield, that military custody is available to hold a suspected al-Qaeda operative caught in the United States, American citizen or not, but we're going to allow the administration, this administration and all future administrations, to change that model if they believe it's best. And to me, we've created a right by our intelligence community, law enforcement community, to do at home what they can do overseas, and if we don't do that, that would just not only be absurd, I think it would make us all left safe for no higher purpose. So to my colleagues who believe we're changing something, all we're trying to do is make sure that the enemy, when they make it to America, that we can hold them and gather intelligence to protect ourselves, no more or no less, and we start with the presumption of military custody, but if the experts in the field, this administration or future administrations, believe that model is not best, they can seek a waiver. That, to me, is what we should have been doing for years, because the battlefield, to those who are listening, is an idea, not a country. We're battling an idea that's a terrible idea. Their idea is if you're a moderate Muslim seeking to worship God a different way, you're not worthy of living. If you're a Jew, a Gentile, you name it, if you don't bow to their view of religion, then you're going to live in hell. So that's what we're fighting. And at the end of the day, this legislation creates a process to deal with the threats here in our own backyard. And unfortunately, does the senator from New Hampshire agree that there's going to be further radicalization, that homegrown terrorist is where this war's going to?
I would agree with the senator from South Carolina that unfortunately there are threats that we face within our own country from homegrown radicalism. But also, let's not forget, this amendment in terms of the military custody applies to members of al-Qaeda or associated forces who have planned an attack against our country or our coalition partners and are not United States citizens. So this provision, really, we're talking about foreigners coming to our country who are members of al-Qaeda and who want to harm Americans when you think about what happened on September 11th. I would also add, I think it's very important that what is in this important provision of the Defense Authorization Act, in response to the senator from California raised the case of Zazi as an example where she thought that case would be impacted by this amendment. That is just simply, with all respect to the senator from California, not the case, because if you look at the language in our amendment, we've given flexibility to the executive branch to conduct the interrogations, to have surveillance. So in the Zazi case, there was surveillance undertaken, and we put express language in here allowing the executive branch to allow law enforcement to conduct surveillance, to conduct interrogation. And I would point that provision out in terms of the amount of flexibility we've actually given the executive branch in this provision. But most importantly, we've dealt with the issue that you talked about, which is in the absence of this provision, when terrorists come to our country and attack us, we are in a position where our law enforcement system, you have to give Miranda rights. You have to give the right to presentment. We're simply saying that you have the option to make sure that you can put intelligence gathering as the top priority. So this, as you've identified and talked about, is a very reasonable compromise. And as you know, my colleague from South Carolina, I would have actually liked to have seen this go further. But this is very important that we bring this forward.
And I would add that Senator Lieberman would have gone further than you, and nobody I respect more than Senator Lieberman, but trying to find a balanced way. So in summary here, 1032, the military custody provision, which has waivers and a lot of flexibility, doesn't apply to American citizens. 1031, the statement of authority to detain, does apply to American citizens, and it designates the world as the battlefield, including the homeland. Are you familiar with the Padilla case? That is a federal court case involving an American citizen captured in the United States that was held for several years as an enemy combatant. His case went to the Fourth Circuit. The Fourth Circuit Court of Appeals said an American citizen can be held by our military as an enemy combatant, even if they're caught here in the United States, because once you join the enemy forces, then you present a military threat, and your citizenship is not a sort of a get-out-of-jail-free card. That the law of the land is that an American citizen can be held as an enemy combatant. That went to the Fourth Circuit, and that, as I speak, is the law of the land.
That's right. That is the law of the land, and that's what's reflected in this provision in the Defense Authorization Act. It's reflective of case law issued by our United States Supreme Court, which in not only that case, but in subsequent cases basically said in those instances what you do have to provide is habeas-type proceedings.
Right. Now, in the Padilla case, that went to the Fourth Circuit. The Hamdan case went to the Supreme Court. Right. American citizens captured overseas. But the Fourth Circuit ruling stands that an American citizen captured in the United States can be held as an enemy combatant, but 1032, requiring military custody, is only for non-citizens captured in the United States. So the bottom line is I think we've constructed a very sound, solid system that deals with homeland captures and homeland threats, and we've created due process that understands this is a war without end, that no one's going to be held in jail indefinitely without going to a federal court to make their case that they're unfairly held, that if the federal court rules with the government, there's an annual review process that would allow the opportunity to get out in the future based on an evaluation of the case. So from a due process point of view, I'm very proud of the work product. I think it makes sense. I think it's a balance between our right to be safe and our rights to provide individuals with due process. But the big breakthrough here is that we're now, for the first time as Congress, creating a system that not only will allow this president flexibility and guidance, future presidents, and it will help us in further court challenges. And quite frankly, the Congress is saying through this bill, if someone is caught in the United States, citizen or not, joining al-Qaeda, trying to do harm to our nation, we are going to create a system where you can be held, you can be prosecuted, you can be interrogated within our values, and we're not going to create an absurd result that if you make it here, none of that applies. And that's all we're really trying to do. Do you agree with that?
I would agree with that. And I would say you've already pointed out how important it is to have these provisions in place to give the officials that do this work every day that we have so much respect for, the ability to gather intelligence, and we need this provision to protect our country from attacks on our homeland. It's so important. I would ask one question of the senator from South Carolina. You're familiar with the military commission?
If I may, I think we need to move to the appropriations conference.
Okay.
Go ahead. Well, we'll do it very quickly.
I will ask you really quickly. Senator from Illinois said that we've only had 6 civilian trials of terrorists. Well,
military commission trials.
Excuse me, 6 military commission trials and hundreds of trials of civilian trials of terrorists. I would ask you, did the administration suspend military commission trials for a period?
The reason we haven't had more is because the Obama administration withdrew charges. Thank goodness they've reinstated charges. There are military commission hearings going on as we speak. I'm in the camp of all the above. Sometimes Article III courts are the best venue, sometimes military commissions. The Galani case was someone we held as an enemy combatant for years, took to federal court and 200-something charges and got convicted of 1. Our federal courts are really not set up to deal with people who have been held as enemy combatants under the law of war, then tried in civilian systems. The Christmas Day bomber, it made perfect sense to me to put him in an Article III court. We found out he was a low-level guy, not one of the higher-ups. But if we catch someone here at home or overseas that's really involved deeply in terrorism in terms of what they know, then we would hold them for a period of time to question them. Then if you wanted to decide to prosecute, military commissions makes the most sense. So the only reason we haven't had more military commission trials is because they've been stopped. I'm not saying federal courts are not an appropriate venue sometimes. I'm saying that when you hold someone under the law of war for years to gather intelligence, which you have right to do, we need to keep them in the same system. And you see what happens when you mix systems. So very proud of the bill. Great debate to have, long overdue. If we can get this enacted in the law, I will say this. America can look anyone in the world in the eye and say we have robust due process. And we can also tell the people in this country that we're sworn to protect that we've got a system that recognizes the difference between an al-Qaeda operative trying to kill us and destroy our way of life than a common criminal. We need to do both. With that, I yield.
Under the previous order, the Senate will proceed to the conference report to accompany H.R. 2112, which the clerk will report.
The Committee of Conference on the disagreeing votes of the two houses on the amendments of the Senate to the bill H.R. 2112.
Mr. President, I ask unanimous consent that the committee report be considered as read. May I proceed?
The report is considered read. Under the previous order, there will be 2 hours of debate equally divided between the two leaders or their designees.
Mr. President, I rise to speak in behalf of the conference committee. I rise as in behalf as the chair of the subcommittee on Commerce, Justice, Science, one of the 3 subcommittees in the conference report. The other is Agriculture, and we are an amendment to this. Senator Cole will be coming to the floor to speak in behalf of his bill that's part of the conference, and the others will speak. I'm going to speak on the Commerce Justice bill. I'm pleased that the Senate is considering the conference agreement on the fiscal year 2012. As I said, I'm CJS. Senator Cole will speak on agriculture, and Senator Patty Murray managed the bill on transportation and housing. She is the chair, and I'm sure either she or her designee will speak about a subcommittee we affectionately call THUD. But let me talk about the CJS conference agreement. You know, this is a great agreement. It's the product of bipartisan and bicameral compromise and cooperation. I really want to thank my ranking member, Senator Kay Bailey Hutchinson, and her excellent staff. We worked hand in hand on this bill. And I want to talk about our colleagues in the House. Much is made about the prickly situation, sometimes between the House and the Senate, but I want to say that working with Chairman Frank Wolf and Ranking Member Chakaf Fatah for their bipartisan support, and there was give and take, sometimes stormy exchanges, but at the end of the day, we work cooperatively and collegially. So as we look at the process, what I want to say is that the conference agreement itself is a really good one. Our bill, the CJS bill, totals $52.7 billion in discretionary spending. Now, we were frugal. It is $600 million below the 2011 level, and it's $5 billion below the President's request. The purpose of this bill is to help create American jobs, make our streets and our neighborhoods safe from violent crime and terrorism, and to support innovation and technology so America can continue to be an exceptional nation. It also promotes trade. We do this through our federal agencies, the Commerce Department, through its Economic Development Administration, Patent Office, International Trade Administration, and the Census Bureau. It also has important agencies related to innovation, the National Institutes of Standards and the National Ocean Atmosphere. Our bill also has in it the Department of Justice, the National Space Agency, and the National Science Foundation. It's got a lot of important things, and it also is a bill that promotes justice. It has in its portfolio the Commission on Civil Rights, the Equal Opportunity Commission, and the Legal Services Commission. Mr. President, within these shrinking funding levels, the CJS conference agreement made priorities that focused on jobs, saving lives and protecting communities, and looking out for the future of our country. Now, the subcommittee faced two really pressing problems that are critical to life and safety. One, our weather satellites. We had to come up with a substantial chunk of money to make sure we had those important new weather satellites that tell us about hurricanes, tornadoes, and other things that are coming. Also, we had a real challenge in providing the adequate funding for America's prison population. These activities are not considered mandatory. They're truly discretionary. We had an obligation to fund them. We also had an obligation to provide security funding to the two conventions to help them underwrite their security concerns. Together, the bare minimum for the JPS satellite was nearly $800 million, $350 million for prisons, and we were able to meet that obligation. But we also looked out for our law enforcement, for our state and local police departments. This bill provides $2.2 billion to support our blue line to keep our police safe, to protect them with the equipment they need, like bulletproof vests, so they can protect us, and the modern tools related to forensic science and enough cops on the beat. We funded BIRD grants at $370 million, a main federal tool for state and local police operations, and cops hiring grants. In terms of federal law enforcement, we met our obligations to the FBI. We funded them at $8 billion. Our Drug Enforcement Agency at $2 billion, the Bureau of Alcohol, Tobacco, and Firearms, and the Marshal Services that are each at $1 billion too. Our marshals no longer necessarily ride the planes, but what they are out there is serving the warrants that go after our sexual predators, and they're also make sure that they fulfill their responsibility to protect our federal judiciary at the courthouses. So those federal law enforcement agencies are at our borders, they're in our streets, they're in our communities, and they're in important task forces protecting our community. In terms of science and innovation, I'm really proud of what we did at NASA, from the space shuttle legacy to our new vehicle for space exploration. We also funded the James Webb Telescope, which will be the successor to the Hubble telescope. It will be 100 times more powerful and will assure America's place as the leader in astronomy for the next 30 years. Our conference agreement was $17.8 billion. It's a balanced space program. It ensures the continuity of or continuation of human spaceflight, does important works in space science, and also bold research in aeronautics so we can be at the cutting edge. We also funded the National Science Foundation, which continues to do that groundbreaking and innovative work that then the private sector works off of. This year, 3 Americans shared the Nobel Prize for physics. One was Dr. Rees at Johns Hopkins. He used the Hubble Space Telescope to look out for dark energy, to look at decaying novas and find out the expansion of the universe. The 2011 Nobel Prize was in chemistry to Dr. Dan Sheckman, working at the National Institutes of Standards. Both discoveries were unexpected and game changers. These Nobel Prize winners were done by those wonderful Americans who, making use of whether it was the Hubble telescope or the kind of work that goes on in our chemistry labs. So we're out there winning the Nobel Prizes, but our bill lays the groundwork for winning the markets. Mr. President, I note that on the floor is the chairman of the full committee, Senator Inouye, and also Senator Cole, who has managed the bill and will speak for agriculture. There are many things that I could say about what we did in this bill, but I think I've summarized the basic themes. I ask unanimous consent that my full statement will be in the record. I will be available to answer any questions from colleagues, but I also want the chairman of the full committee to have an opportunity to speak, and certainly Senator Cole and Senator Blunt. And I want to say a special word to Senator Blunt. When Senator Cole had to be temporarily off the floor, I want to thank him for working with me, because we really moved this bill. And we showed we knew how to govern, we knew how to move legislation, and if we work this way, we're going to get America moving again. Mr. President, I yield the floor.
President.